I'm ready when you are.
Yeah, okay, so I'm gonna start.
Okay.
Contract case Barnes versus Trees by Claudia Huaman and Lucas Edmondson. The facts of this case are Vendowin is a Washington corporation engaged primarily in the business of distributing punchboards. On July 24, 1973, Warren Trees, who served as vice president, spoke before the Washington State Gambling Commission in support of punchboard legitimacy. Trees made a statement to the following effect: I will put $100,000 to anyone to find a crooked board. If they find it, I will pay it. On July 25, 1973, the plaintiff Barnes heard Triss's previous statement while watching a TV news report before the Gambling Commission. A number of years earlier, Barnes purged through fraudulent punchboards. On July 26, 1973, Barnes called Trees to reveal that he had two crooked punchboards. Trees assured his statement and additionally informed Barnes that the $100,000 was safely being held in escrow. On July 28, 1973, Barnes traveled to Seattle bringing the punchboard for inspection. He met Trees and Bendowin's secretary treasurers in his office, produced one punchboard, and received a receipt for presentation of the board signed by Trees and witnessed by Bendowin's secretary treasurer. Barnes was informed that the punch board would be taken to Chicago for examination. On August 3rd, 1973, before the Washington State Gambling Commission, the parties met and Barnes produced his second punch board during the meeting. For the issues, both Trees and Van de Wins refused to pay Burns $100,000. Burns then began this breach of contract action against both defendants. The trial court found that Trees' statement while talking with Burns constituted a legal offer for a unilateral contract and that Burns' production of two dishonest punch boards constitute an acceptance of the offer. Did Burns and Trees equally manifest acceptance to an arrangement that create an enforceable contract? If the answer is yes, was the corporation Van assured under the contract either by having invested Trees with apparent authority to the contract in its behalf or by later ratifying the agreement?
So, for the rule of law, when a public expression is made for humor, one may not consider it an opportunity for verbal contract. However, in the case that a reasonable person may understand the statement to be legitimate, it may be binding in the case that a person hearing it chooses to accept. And here we have a quote from another case. If a party's words or acts judged by a reasonable standard manifest an intention to agree in regard to the matter in question, that agreement is established, and it is immaterial what may be the real but unexpressed state of the party's mind on the subject. And then the application of the law. Although the original statement of Treese can be taken not serious, the subsequent statements, conduct, and circumstances show an intent to lead any hearer to believe the statements were made seriously. In addition, Treese specifically restated the offer over the telephone in response to an inquiry concerning whether the offer was serious. Treese, when given the opportunity to state that an offer was not intended, not only reaffirmed the offer but also asserted that had been placed in escrow. Nowadays in society, it is known that gambling produces a great income and that large sums are spent on its advertising and promotion. In that main context, it was a credible statement that $100,000 would be paid to promote punch boards. The trial court considered Treese's promise of $100,000 as a valid offer for a unilateral contract. The offer made promised that a contract would result upon performance of the act requested. Performance of the act with the intent to consent, the offer constituted acceptance. The trial judge entered a specific finding that Barnes performed the requested act of acceptance when he produced a rigged and fraudulent punch board. We concur with the trial court's holding that a binding unilateral contract was formed between Barnes and Treese, and uphold the conclusions of the trial court in that regard. And in conclusion, Barnes affirms that Vendewin impliedly ratified the contract through agreement by remaining silent and failing to repudiate or disaffirm the contract. The trial court's findings were affirmed because Vendewin failed to evade or stop the formation of fulfillment of the contract by tacit consent. Here's our works cited. Thank you very much.